Case number 111972, David Neighbor v. Westar Energy, Inc.
Good morning. May it please the court, Judge, I would ask for 5 minutes of rebuttal.
5 minutes is granted.
Yes. Good morning. I represent David Neighbors in this case. He's the appellant. This case was originally filed as an eminent domain action in Johnson County District Court. After the eminent domain concluded, Mr. Neighbor filed an appeal that was docketed as a Chapter 60 case in Johnson County District Court. Sometime after that, for a variety of reasons, including counsel at that time's health, a motion to dismiss without prejudice was filed, and counsel for both Mr. Neighbor and Westar signed a stipulated order of dismissal without prejudice, and the court dismissed his appeal. Within 6 months of that time, a new case was filed using KSA 6518, the Kansas Savings Statute, to bring the new appeal to the court. Westar then filed a motion to dismiss in the district court, stating that the Kansas Code of Civil Procedure does not apply to appeals of eminent domain, and the Kansas Code of Civil Procedure only applies to the actual trial of the case. Judge Elliott in Johnson County agreed with Westar, and that's why we're here today, because we've appealed that ruling. So our argument boils down to, it is our position that unless the Kansas Eminent Domain Procedure Act specifically is contradicted or contravened by the Kansas Code of Civil Procedure, then the Kansas Code of Civil Procedure applies to the appeal from the time it's docketed as a new civil action all the way to the conclusion of the appeal. Westar's position is it's only applicable to the trial itself. Now, we believe for a variety of reasons that the lower court erred. Specifically, the plain language of KSA 26508 states that the appeal should be docketed as a new civil action. The docket fee of a new court action shall be collected, and the appeal should be tried as any other civil action. So I think the plain language in and of itself states this case is to be a Chapter 60 case. It's docketed as a Chapter 60 case. Now, there is a variety of cases that this case in the Court of Appeals dealt with as well that talks about the Kansas Code of Civil Procedure applying to aspects of the appeal that aren't just the actual trial itself, and those are cited in our brief. Specifically, the most recent case was the Miller v. Glacier Development case. And in that case, the court said that KSA 6202 didn't counteract or contravene the Kansas Eminent Domain Procedure Act, and it was okay to use. From there, our brief cited the Landau case versus City of Overland Park. In that matter, the court said that amendments to pleadings pursuant to KSA 6215 was acceptable. And so, therefore, those are two examples when the court applied the Code of Civil Procedure to an aspect of the case that wasn't just the trial. You also see, Judge, that we cited to the Shea versus KDOT case, and that was a situation where the court did say the lower court abused their discretion in using and dismissing the case as a discovery sanction, but at the same time this court said that they agreed that Chapter 6 remedies are available in an eminent domain appeal. There was two other cases that we cited that are very similar, the State Highway Commission versus Hembrough and the Deffenbach case. One case that was not in our brief that I think is worth noting is the Glover v. State Highway Commission case. And that is cited 147 CAN 279, and it's a 1938 case.
Excuse me, counsel, have you cited that to us or opposing counsel before this moment?
I have not.
Okay. We cannot consider it.
And that's okay. And Judge, so I think some of the arguments that Westar made in the past is that the idea of an eminent domain case is to be expeditiously finalized. And that is for a variety of reasons. So that's when that eminent domain case is originally filed, that title to the land that's being condemned can be transferred to the condemning authority, and so that the project can move forward. So I don't disagree with anything that Westar has stated in regards to moving the case along quickly. But where I think our disagreement really hits a wall is Once the appeal from the original eminent domain case is filed, and if it's filed timely and it's perfected, then at that time the title to the condemning land transfers to the condemning authority and the project moves forward. The only issue left to the district court at that time on the appeal is the amount of just compensation. So this idea that the reason that the savings statute can't be used to refile 6 months later because it would slow down the case, I think doesn't hold water, because title of the land's already transferred, the project moved forward, and all that we are left with at that time is what are we going to do about what the just compensation is.
Counsel, in addition to the authorities you've already called our attention to, do you have any legislative history support for your position, or substantive background considerations at the time the current statute, current EDPA or the predecessor statute were passed?
There's nothing that's exactly on point, but I will say that if you go back all the way to the Eminent Domain Act of, I believe, all the way back to 1938, you'll see that this language of a civil action is always found. And in the legislative history, for a variety of reasons, the code seems to be continuously liberalized in regards to giving landowners more rights and giving them more opportunity. And so I think the intent of the legislature was to allow the landowners more rights, and that was enacted back in 2006. There were some changes to the language to give landowners more rights, and so I think the intent would be to give landowners every opportunity they have for just compensation.
Kind of a trend of legislative enactment over time, would you
Yes.
argue? Okay.
Was it in 2003 that they added the word new civil action?
Judge,
Well, civil action was there, but was new added at that time?
I cannot tell you if it was 2003 or 63. I can tell you that originally, when the original Eminent Domain Act back in the 30s was enacted, it simply said, try the same as other actions.
Right.
But I don't believe that the word new was put in the last 15 years. I think it was prior to that.
Counsel, you appealed the decision of Judge Elliott to the appellate courts, correct?
Yes.
And what was your time requirement for filing that notice of appeal?
To the Supreme Court or the original eminent domain action?
The Supreme Court.
I believe it was 30 days.
And I believe we've held that that is a jurisdictional requirement, is that correct?
Yes.
So if you had timely filed your appeal with this court, and then you voluntarily dismissed your appeal, and then wanted to file 5 months later to say, I now want to bring up my appeal again, what is your position on whether this court would allow you to do that?
I don't think this court would allow that, but I think it's not analogous, because I think the appeal that we file with you isn't a new case, whereas the appeal in an eminent domain action is a new case in its entirety that deals with the issue of compensation. So I think your scenario, I don't know if that would be allowed.
Even though what you are attempting to do from the appraiser's award is to appeal to the district court, you don't think an appeal in one context is an appeal in the other, and therefore it is jurisdictional on the time frame?
I don't think so. And here's why. And I think because once that original appeal in the district court is filed, it is treated as any other civil action. And in any other civil action, you have the remedies that the Kansas Code of Civil Procedure allows available to you. And one of those remedies is 6518. And I think when I file an appeal to come to the Supreme Court, I don't think all of those remedies are available, specifically 518. Because this isn't a new action that we're filing to bring in front of you, whereas in the district court, it's a new action in and of itself, according to the statute.
Would you have any authority to support your distinction between the two?
I do not.
Well, you do have 6518 that talks about if any action be commenced within due time.
Yes, and
your argument is that when you appeal to the appellate court, you're not commencing an action.
Right, it's a continuation of an action. And I might be wrong on that, but I do believe that at the district court level, when that new action is filed, you have 6518 available to you.
Counsel, if 6518 does not apply, what did the district court mean when it dismissed the first appeal without prejudice?
And I don't know. And that's one of the questions that I have never really had answered, is if that first case, the first appeal was dismissed without prejudice, and it was signed off by both counsel for Mr. Neighbor at the time and Westar, is if at that time the court and opposing counsel didn't believe that it could be refiled, I don't understand why it was dismissed without prejudice. So I think the court brings up a good point.
Well, in line with Justice Stigl's question, was given the other argument, maybe this is a more appropriate question for Mr. Hebtig, but what's the status of that order if it was an order that was entered that was invalid? I'm talking about the original order of dismissal. I mean, the judge, and I don't know if it was the same judge, it was Judge Elliott or another district judge, dismissed the case without prejudice. The appellee's argument is that it can't be dismissed without prejudice given the time frame, right?
Yes.
So what's the status of that order?
I guess in that scenario, that would almost make that order invalid.
And
Therefore the appeal would go back, and it would still be good from the first time, and it wouldn't have been dismissed.
I think
Are
Does the
you
court-
familiar with the decision, the 1968, or 57 decision, I guess it is, of Howard versus State Highway
Judge.
Commission? Can you address why that's distinguishable?
I think it's distinguished for a couple of reasons. The first reason is I think the language that was quoted in Westar's brief, I think that was dicta. The second reason is it was a very convoluted fact pattern to where in Howard, what happened is the landowner filed an appeal from their award, and then the appeal was continued a number of times, and the court eventually dismissed the matter. At that time, the appellant filed a motion to reinstate the appeal that was denied, that he then took up to the Supreme Court, that denial. While that was hanging out there, he filed a second lawsuit that wasn't a reinstatement of his original rights for a specific amount of damages. And so I don't think they're analogous, because there was this very convoluted situation where they were trying to reinstate a previous appeal, not use the saving statute, and then they filed this second lawsuit. So I think the facts are different enough that it's not applicable to this case. I see I've gone over my time. Does anyone have any more questions before I defer to Mr. Hebdig?
Any more questions? Thank you, counsel.
Good morning. Again, may it please the court, my name is Michael Hebdig. I represent the appellee Westar Energy, Inc. And as counsel pointed out, it is Westar's position that the Eminent Domain Procedures Act anticipates and encourages a speedy resolution of issues when it comes to condemnation action. And I don't believe you need to look further than the act itself in order to realize that. KSA 2650.
What's your response to his statement that the only issue pending at that point is just compensation, and that title has already transferred?
I would agree that the Eminent Domain Procedure Act forms the pleadings, and I think that's the crux of the issue at bar here. The Eminent Domain Procedure Act forms the pleadings, and the act provides that the only issue to be determined at a new trial, de novo trial, is the amount of just compensation to be determined.
So why is it really slowing down the thing that the statutes are designed to speed up? That was his point.
Why is
permitting this appeal to go forward really slowing down anything that the statutes are designed to speed up? That was his point.
This would be, in my opinion, this is slowing down the ultimate finality of the case. And when we look at, for instance, KSA 26504, that provides that these appeals are given priority over other
Well,
cases.
Counselor, does Westar have the land?
Yes, Judge.
And so it can proceed to use it and utilize it for the purpose for which it was condemned.
Correct.
And they've already paid the original appraiser's amount into court?
Correct, Judge.
And so the only one to be harmed, Westar has what it needs, and it can proceed with its project. The only one to be harmed by delay is the landowner if they were to get more money. And of course, they take the risk that they will get less money and have to repay.
Sure.
But if it's been paid out. But why isn't the appellant here the only one to be prejudiced by any delay?
Well, when we look at who has the power of eminent domain, it's not individuals. Not any one person has the power of eminent domain. We have utility companies, corporations, and we have governmental entities. And these entities are rather well known for turnover. And I think there's a risk that when we extend these appeals out, and in this case we have an appeal that is docketed some 22 months after the appraiser's award is issued, and that's the facts of this case. It could have been longer, could have been shorter perhaps, but we have the issue where we have spoliation of evidence, we have turnover with employees. Those fact finders, or those people that were in the situation who knew the facts of the case, they knew why we were performing this project, they knew what the engineering specs of the project were.
Is that prejudice any different than any other civil suit? If you had a corporation bringing a civil suit on some other issue besides eminent domain, and if there is no difference in that prejudice, spoliation of evidence, turnover of employees, then that's already been addressed because the legislature has allowed that under 6518.
Well, I don't know that would be any different, but I believe that the court's prior rulings with respect to how eminent domain cases are handled and the legislative intent of providing that the appeals must be docketed within that 30-day time period. It must be docketed. I mean, that's a jurisdictional issue that the legislature set out, that it must be docketed within those 30 days after the filing of the appraiser's report. And then that appeal is still given precedent and priority once there's an appeal taken. So I think it's clear from the statutory language that the intent is still, even after the appraiser's award is paid into the court, and after the condemning authority has the rights in the land that it expects to obtain through its condemnation action, I believe the legislative intent is clear from the statutory language itself that the matter is to proceed in an expeditious manner.
Given all these concerns that Westar has with timeliness, that you've just recited a lot of those concerns, I guess what occurs to me is, what did Westar think that it was doing when it stipulated to a dismissal without prejudice?
Well, at that time, Judge, the dismissal, the plaintiff had requested a dismissal, and the understanding was simply we don't intend to pursue this matter. And so there was an agreement to dismiss.
It was an agreement to dismiss without prejudice, right?
It was. And the problem with allowing the KSA 6518 to apply is this would open the door for any party, whether it be the condemning authority.
Well, I understand that. I guess what I'm getting at, though, is it just strikes me at least that if your client has these concerns with timeliness, they didn't seem very concerned with that if they agreed to a dismissal without prejudice.
Well, Judge, that's what I was going to is Westar had no intention of filing an appeal in this matter. Clearly, Westar was at least satisfied with the appraiser's award enough to the extent that it didn't intend or desire to have an appeal. It was presented as an offer to Westar. We, the landowner, we're willing to dismiss this. Is this okay with you? Be that with prejudice or without prejudice, it's better for Westar to have a dismissal so it's not being forced to prosecute and litigate an appeal which it didn't want to bring in the first place. There's additional cost and expense in forcing a landowner to proceed with litigation for both parties. And if the non-aggrieved party, as you will, didn't want an appeal in the first place, it would create sort of a catch-22 in this event. And I believe this is illustrated by the idea that if I'm an aggrieved party and I want some additional time to decide whether or not I'm going to appeal, the court of appointed appraisers, they file their report, and I've got 30 days to file my written appeal. If I file my appeal on day 30, and I'm still not real sure if I want to go ahead and litigate this. Oftentimes, especially with landowners, there won't be a formal appraisal paid for and obtained prior to the court-appointed appraiser's hearing. That's something that oftentimes is hired for the appeal itself. I haven't spent that money yet. I don't know if I want to go down the road. Why wouldn't I file my notice of appeal and then on day 31 call opposing counsel and say, you know, I filed an appeal on this, let's go ahead and dismiss it. If it gets dismissed, now I've got another 6 months that I can go ahead and file my appeal. I can take that time, and it would seem, if I'm the condemning authority and I get that offer, okay, so my option is to either agree to dismiss this thing or start the litigation process, which I didn't want in the first place, and start spending money to play some game of judicial chicken with the landowner or the aggrieved party as to whether I think that they are really going to appeal or they're just buying for more time for an appeal. And now I'm going down the road and I'm spending money on that when I believe the statute is quite clear that there's one way that the pleadings in an eminent domain action are formed.
Mr. Heptig, I'm sorry to interrupt you there, but I'm going to go back to the question asked of the opposing counsel. If you've got an order that, as I understand, you're arguing that there was no way the judge could issue an order of dismissal without prejudice. Is that correct?
That is correct, Judge.
So it was a de facto an order with prejudice. So the judge dismissed it without prejudice. What does that do to the original dismissal of the action?
Judge, I think the best analogous case there is probably Shea, and that is and potentially Howard as well. And Howard in so much as the party cannot invite error into the proceeding. And
well, who invited error? I mean, it seemed like it was a tandem.
Well, it would be Westar's position that the error was invited by the landowner in this matter because it was the landowner who approached Westar and said, we'd like to dismiss this case. And again, it's certainly in Westar's best interest not to litigate a case where the only outcome potentially is we're going to pay more money, at least in cost of litigation and potentially in terms of a change in award. And when approached by the idea that the landowner is willing to dismiss, it's an easy decision for the condemning authority in that case to agree to a dismissal. In that event, I think that the court needs to look at was the judge's decision to dismiss that case in any way, shape, or form, the dismissal itself, with or without prejudice, ignoring that fact for a moment, but was the decision to dismiss the case in error? And in this case, I don't believe that was an error. It wasn't like the case in Shea where the judge overstepped his bounds and dismissed for a discovery sanction when a new party had just gotten involved and only been involved for some 60 days, and there was vast confusion about what had transpired and all the changing attorneys and lawyers. This court decided that was the judge overstepping his bounds and taking upon himself to dismiss this matter for reasons that were improper.
Do you think, counsel, that in an ordinary Chapter 60 civil case, if both parties presented the judge with a agreed order to dismiss without prejudice, do you think that the judge would it be proper for the judge to take that stipulation and request and enter an order of dismissal with prejudice? Could a district court judge do that?
Under just the facts that you stated, it would likely be improper if there wasn't some other, some other issue in the case. I mean, I think the judge could dismiss with prejudice, but not for the reasons because the parties asked for without prejudice.
And what would justify the court in doing that? What's an example? I think that's what your question is. How could that happen if the party stipulated to dismissal without prejudice?
Well, what I was referring to is similar to the issue in Shea. If there were separate discovery issues that were going on and the judge decided to use that as a discovery sanction, presuming that it rose to that level, I think the judge could sua sponte dismiss or dismiss with prejudice on other grounds, but not for the grounds that the justice was asking about when the parties requested a dismissal without prejudice. I don't believe the judge could take it upon himself and dismiss with
I have
prejudice.
another couple questions. I asked your opposing counsel whether he had any legislative history support or substantive background consideration support for his position. I want to address the same question to you. And then I also want you to respond to his trending argument that the statutory trend is toward more rights, more ability for landowners to contest.
Well, and to be honest, Judge, I think really the response to both of those questions can really flow together, and that is, as we stated in our brief, it is Westar's position that the intent and the history of these statutes has remained largely the same since the Howard case in 1957. The Howard case in 1957 looked at the predecessor to the Eminent Domain Procedures Act and looked at the predecessor specifically to KSA 26508, which from a procedural standpoint is by and large the same in that you've got 30 days to file your written notice of appeal from the appraiser's award, and then it is docketed and tried as another action. Similarly, the court
It's tried as what? It's tried as any other civil action.
Correct, Judge.
And I guess where I'm having a problem is, this court has been recently fairly literal in reading statutes and saying the legislature needs to say what it intends to do. And I'm having a little problem when I look at 26508A that says the appeal shall be docketed as a new civil action. The docket fee for a new court action shall be collected, and the appeal shall be tried as any other civil action, unquote. And I don't know how the legislature could be any more clear that what we have here, once you meet that 30-day deadline and file this, you're filing a new civil action, a Chapter 60 action. And once you file a Chapter 60 action, then you go to 518 and it says if any action is commenced within the time frame, you have the savings clause. And I'm not confused. I see what the legislature meant to say, and they did say it. So why do we look to dictum from 1957 when we have the language right there?
Well, I think what the biggest distinction there is the history and the case law that provides, and this is quoting from the City of Wellington v. Miller, and that is that, and there are several cases that hold the same way, and that the provisions of 26508 provide that the appeal should be tried as any other civil action applies to the presentation of the fact, and here's the key part, and not the formation of the pleadings. It's the formation of the pleadings, and that is the crux of this issue. The pleadings are formed per KSA 26508. That is the only way that you can perfect your appeal from an eminent domain appraiser's award. And 26508 requires that appeal be docketed within 30 days of the appraiser's award.
And you formed that pleading and filed it within 30 days, and you took the same pleading that was formed in the same way and you refiled it within 6 months under 6518. I don't understand why that is changing the form of the pleadings. That's just following the procedure as any other civil action.
Your Honor, I respectfully would suggest that that's a jurisdictional issue, that unless that written instrument, that written notice of appeal is filed within those 30 days, then the district court does not have the jurisdiction to hear an appeal. The Eminent Domain Procedures Act provides one way for an appeal from an eminent domain procedure or from an eminent domain award to be docketed. And that docketing must happen within 30 days. If the legislature intended that there be an additional, or if it's filed again, you've got an additional 6 months. If they wanted to incorporate 518, they certainly could have. But the legislature specifically said it has to be done within 30 days, and the general rule in Kansas is that the specific governs over the general. The specific rule here is that in order to properly docket your appeal, in order for you to have standing to pursue further adjudication of what you are owed for whatever rights may have been taken, or really it's for the compensation in general. Either party, you have 30 days to do that. Similarly, if the condemning authority, if they don't get the money paid within 30 days, it's all for naught. Everything that had just happened is dismissed. They don't get their rights, and the judge in the action does not have the ability to enlarge that time period. There are cases cited in the brief where the attorney mistakenly calendared the time for appeal, and that is not something that the court can look at. It's a jurisdictional issue. The court does not have the power to extend that or enlarge that in any way.
I just have one more question, Chief. Is there any other factor that we should consider other than speedy resolution that contravenes the nature of EDPA if 6518 is utilized?
Well, again, I think the idea that
the whole idea is speedy resolution. Is there anything else that we
I
ought to be looking at?
I think there is, Judge, and that it's not just a speedy resolution in terms of timing it from A and B, so to speak, but the idea that this case was docketed as an appeal. There were 15 months worth of litigation, and then it was terminated and canceled, and now we're starting anew. So anything that may have been brought in the first place is, or any work done in the original case is perhaps not worth a lot, and the condemning authority is now forced to defend a second appeal when the legislature only provides for one, and we have those same issues that we discussed earlier in terms of we've got to rehire experts, we've got to take our engineers, take our individuals with the boots on the ground, and go back to a case or back to a project that was began in 2011.
How would that be any different than, say, you had a medical malpractice? You'd have to go back and get your experts lined up again and do all that sort of thing. I don't hear you say anything that's unique to a litigation over the value of land, and that's what this is. It's just the litigation over what is the value of this land versus any other litigation. You've got all of those same problems, and the legislature has made the public policy decision to have a savings statute.
Well, I think the distinction is the legislature has made the policy that this is to be an expedited process. I think the legislature...
I'm sorry, I'll let you finish your answer, and then I'll have a question as a follow-up. Go ahead.
I think the legislature was clear that the public policy is that this is to be an expedited process, even during the appeal phase. And that is the distinction. If we're talking about a medical malpractice case, while that is certainly not an area in which I practice or would be familiar with, but I know of no statutes that provide that those cases are given any sort of priority, or that encourages a clear or provides a clear legislative intent that those types of claims and cases are handled and brought to fruition in a expedited manner.
When would the money actually be in the plaintiff's pocket in a typical case?
In a typical case, the appraisers, they have their hearing and they issue their appraiser's report. The condemning authority...
And then if that's appealed to the district court,
Even
Is
if it's
that-
appealed. Even if it's appealed, the money has to be into the district court within 30 days of the filing of the appraiser's report. And at that time, the landowner can take that money out of the district court without prejudicing their rights. So they can, as soon as it's paid in, it can come right back out of the court's trust account to the landowner, and that does not prejudice any appellate rights.
So why would the legislature be saying that the subject matter on appeal is limited to the amount of damages? That's 26,508. And then why would they say under 26,504 the appeal is expedited to this court? What's the public policy to be served by expediting this if, as opposing counsel said, the deed is already transferred or the title is transferred and the money's in the plaintiff's pocket? What's the policy?
On the first issue of why are we limited to only dealing with the valuation and not being able to bring any other outside items? I believe the public policy is to prevent the idea that, and this has been tried in several cases, where a landowner will try and attack the proceeding itself as being improper, saying either the classic example is this is not necessary for the lawful corporate purpose of the condemning authority, and collaterally attack the idea that this project, whether it be a road or pipeline or power line, this is not necessary for this entity's lawful corporate purpose. There was an error in deciding that this petition should have been granted, and so we can have some other resolution of issues that may call into question the entirety of the taking itself. And I think the public policy there is preventing any discussion about whether that was proper. There's a vast line of Kansas case law that requires if you want to attack the taking itself, then the landowner is required to file a separate civil action, generally in the form of an injunction, to try and prevent that.
What about the second part of my question?
And on the second part of the-
What policy is to be served by having an expedited appeal to the Supreme Court that takes precedence over all other cases?
Well,
If the only issue is the amount of damages and the landowner has the money, or could have the money in his or her pocket, and the title's transferred, what's the policy?
without having any legislative background, I can only speculate. But again, I think that the part of the policy is having a fast and expedited resolution assists when you're talking about governmental entities and corporate entities where you're going to have spoliation over time, and you're going to have a rather constant changing of the guards, if you will, as to the parties, the power parties that are behind the action itself, and you're dealing with budgets. I think the intent is to maintain that and reduce the uncertainty that time would allow.
It seems to me, I'm sorry, go ahead.
I just want to ask a follow-up. Can you explain for me why we would be told the appeal in these cases takes precedent over other cases, which would appear to be a request or a mandate for us to move this along, and then your position is that the saving statute does not apply? It just seems a little strange, and I just was curious if you had a response to that.
Well, I don't
I know
that
you said that 518's application here would be inconsistent with the idea the legislature you believe has proposed, which is to move things along, make it expeditious. But in terms of the landowner's point of view, would a landowner be puzzled by, gee, this is such an important issue, it has to be pressed real hard through the courts and very fast, precedent over all the cases, yet I can't I can't refile under the saving statute. Do you see any contradiction there at all?
I don't believe I do, Judge. The idea is that the legislature did provide that the landowner, if you think this is an important enough issue, or maybe not an important enough issue, but a substantial enough disparity in value, because all we're talking about really is value, that you have those 30 days, and you need to take advantage of those 30 days to file your appeal. And the courts history has been very clear that those 30 days, they're frankly sacred. I mean, if you don't get the award paid within 30 days, condemning authority, you're out of luck. You just lost everything you've done beforehand.
So the landowner's getting special treatment in terms of an expedited appeal, but he's getting prejudicial treatment in his inability to use the saving statute. That's what I'm getting at.
Well, I don't know that it's prejudicial when the landowner is the one who requested that the underlying action be dismissed in the first place.
But if this were a regular Chapter 60 case, that would not be an issue, correct?
Indeed, but again, the case law is very clear that the Eminent Domain Procedure Act forms the pleadings. There is no petition. We have a notice of appeal. There is no answer. The issues are what is value. And that's why.
Let me ask this. Why would the legislature say that we're going to give preferential treatment to the landowner in these eminent domain proceedings? This type of case, yet we're going to penalize the landowner and cannot use the saving statute in these proceedings. I'm just saying if you see any inconsistency there.
When you're saying they're giving the landowner preferential treatment,
his case is moving along, taking priority over many other cases on our docket. For some reason, and you've explained to us, the legislature wanted to do that. You've given us a policy consideration. What would be the policy consideration for the legislature saying, we're giving you special treatment over here, but you're getting prejudicial treatment over here, and you cannot use a saving statute?
I don't know that the legislature is giving the landowner preferential treatment when it says it has to move along quickly. I think that benefits.
This type of case is getting preferential treatment.
Indeed,
Okay.
the case type, correct.
But this type of case is getting prejudicial treatment, and it cannot use 6518, is my point.
I don't know that it would be prejudicial in terms of the case type. I think it's consistent with the idea that we need to move this along, and it harkens back to the judge's prior question about why is it that we can't bring in anything in a eminent domain appeal? Why are we limited with just an issue of valuation? Why can't we bring in those other items? Because frankly, this isn't just any other Chapter 60 case. If this was any other Chapter 60 case, I could move to amend my petition and bring in other collateral issues. That's not allowed. The only issue is valuation, and the legislature is very clear that the hurdle that you've got to meet in order to have an eminent domain appeal is to get your appeal filed within those 30 days. And then the only formation of the pleadings are what was filed in those 30 days, the notice of appeal, and that sets up the question, is what is the value?
And thereafter, after that 30 days has been met, is there any provision for how long it takes to resolve the issue of valuation? In other words, you indicated there was 2 years of litigation after you met the 30 days, and if there's no limitation on how long it takes, then how is not using the savings provision meeting that goal? If they can litigate for 5 years, what difference does it make if they litigate for 6 months and then take 6 months off and then come back again? What is there to indicate that the resolution has to be expedited rather than the commencement?
Well, I think from a practical perspective, the legislature can tell you you need to get it started by such and such point, 30 days, and then you need to give it preference over other matters. I think from a practical standpoint, it would be difficult for the legislature, well, maybe not difficult for the legislature, but it may be difficult for the district court to 100% comply with some hard and fast deadline as to the ultimate resolution of a jury trial when there are other cases which would take precedent even over this type of case.
Justice Steele, you still have a question?
No, thank you.
Okay. Any more questions? Thank you, counsel.
Thank you.
If this court, Judge, I'll be brief. I'll touch on a few things that Mr. Heptig said. Just a moment ago, he talked about how this appeal isn't any other civil action. That's completely contradictory to the statute. The statute says the action the docket fee of a new court shall be collected and the appeal should be tried as any other civil action. So it is just like any other civil action. He also said that the formation of the pleadings are governed by the Kansas Eminent Domain Procedure Act and they can't be changed. I think that's contrary to previous court's decisions. Yes, the formation of the pleadings are governed by the Eminent Domain Procedure Act, but the Landau case that I cited in my brief, this court specifically, prior to trial, allowed 6215 to be implemented to amend the pleadings. I'd also like to point out that...
But you can't amend to bring in necessity or other collateral issues. I think that was the point.
I agree. I think that's right. And I think Justice Johnson was going down the road that I'd like to go down here, and that is a lot of the issues that Westar is complaining about, that the use of 6518 would produce are the same problems that would be produced in any civil case. I don't think they're unique to any other civil case in which the saving statute would be used. And if this is truly a Chapter 60 case that's the same as any other civil case, then that shouldn't matter. And lastly, there was a lot of talk about jurisdiction and this 30 days is very sacred. We perfected that. Our initial appeal was filed within 30 days pursuant to the statute. Justice Beyer, you had asked about a legislative trend. I think the most recent legislative trend that shows the legislature's intent to increase the landowner's rights is in 2006. There was a Douglas County condemnation case. And I believe what had happened was some attorneys filed their appeal within 30 days, but they did not file it as a new case. They filed it in the initial eminent domain case, so they didn't pay a docketing fee. And the district court judge in Douglas County dismissed the case and said that 30 days is jurisdictional, and since you didn't file a new case like you were supposed to, you just filed a notice of appeal in the old case, and you didn't file a new docketing fee, therefore you cannot appeal. The legislature went back and changed the language and made the docketing fee a non-jurisdictional issue, to where if you don't pay your docketing fee, that doesn't automatically get your appeal kicked. And it was retroactively enacted 3 years to allow those landowners to refile their appeal and pay their docketing fee and to let the appeal go forward. So I think that's a good example of this legislative trend that we were talking about. I don't have anything else for the court unless there are other questions of me.
The statutory language says the appeal should be tried as any other civil action. It sounds like you'd like us to go beyond just the mere trial of the case and expand it into this area.
I think so, and I think, Judge, I was getting ready yesterday and I'm going in front of the Supreme Court, and I found myself looking in Webster's dictionary to what trial and action meant. And so I think where Mr. Heptig and I are disagreeing is, does the trying of a case and the trying of a new action only deal with the actual trial? And I think our interpretation is that language doesn't mean it's just the trial, it's the entire case. And I think that the statutory language in the case law supports it.
In your view, tried is the same as accepted or treated?
I think so, yes.
Or prosecuted.
Pursued.
Yes. Yes. Pursued, I think, would be a good synonym.
Any further presentation?
I don't have anything else, Judge. Thank you for your time.
Any more questions? Thank you. Thank you both for your arguments this morning. Court will take this matter under advisement.